All right. We are 5 minutes late, in the class. All right. Good evening, everyone. Good evening. Shall we start? Let's have one more minute before other students join in, and then we begin. We start in a minute. So, any doubts from the previous class? Anybody, any doubt? No? Thank you, Nakul. So, what are we going to do today and tomorrow? Thanks, Manju. Is that we are going to cover the jurisdiction of the Supreme Court today. Then we also look at special leave appeal in the Supreme Court, how it is different from other kind of appeals. Then we move on to power to do complete justice by the Supreme Court. So we will begin like this. We will try to figure out, we have a Supreme Court here, and then all other courts are subordinate to it, whether it is high or subordinate courts. Then we look at the jurisdiction of the Supreme Court, and we complete it today. The kind of question which is asked from here, we have already discussed that, so no need to go into the questions. Supreme Court. So we are entering the power of judiciary, in other words. And in this, we have already discussed to some extent what is known as that we have an original jurisdiction, we have appeal based or appellate jurisdiction, then we also cover writ jurisdiction, Then in addition to this, we also have reference or suggestion by the Honorable Supreme Court, and then we have some special jurisdiction. In this, the major purpose is to establish or ensure that there is rule of law, and in addition to rule of law, there is justice. With these two major values in mind, we try to figure out special leave petition. Let's put in short form. Law declared by Supreme Court. Then not only this, we also link this with power to do complete justice. We move further and we try to compare these two with this, if possible today, if not possible tomorrow. Then using these powers and jurisdictions per se, that the jurisdictional area of the court, we also figure out what Constitution and the Supreme Court has to say on question of review. In this, one part is review of judgments and orders of Supreme Court. And here we focus on what the Honorable Court has said, that this is all about corrective justice. All right. Which justice? Corrective justice. And then we move further and we link this with Article 13 as well as Article 32 precisely, and one more article as part of the discourse. We try to figure out how Supreme Court has enlarged or expanded the meaning of procedure established by law. Procedure established by law. When we merge it together, or precisely when we focus on this and we bring, let's say, this one and this one, these two in mind, we enter the domain of judicial activism. Also attached is PIL, or public interest litigation, and today and tomorrow we try to figure out how this is different from what is known as judicial overreach. Difficult? Is it difficult the way I explained? Or is it fine that this is a pure map of how you have to read it? This is how we have to read. If you try to figure out, let's say, Article 130, you want to move forward till Article 147, then there are many other articles like Supreme Court rules, enlargement of the jurisdiction of Supreme Court. Those articles are very basic in nature. You don't need to put your mind in it. But from the main answer perspective, we will of course go through these articles as well. But the larger thing that you have to cover today and tomorrow is this. All right. And my agenda for today, let's hope I'm able to cover it, is to at least discuss till here procedure established by law and all these different aspects of court's power or the honorable court's power. If I have to think or speculate examination perspective, then something on writ, especially habeas corpus writ. If you go for pronunciation, habeas corpore, sometimes they speak like this, but for simple perspective, habeas corpus petition, writ, it's one of the writ. Something could be asked about that writ in the pre-examination or the main examination, because that writ is in current affairs. So go through that. We have already covered it in good detail in the fundamental rights part. That lecture is also available in your on your LMS platform, so you can watch there. All right, let's begin. ठीक है? Have you all written it? ये लिख लिया सब लोगों ने? No? Just make it फटाफट. Make this map in your copy, so that whenever you open your notes, na, you have a pure idea what you have gone through. Just make this fast. While you make it, let me get rid of my coat. Okay, you have made it. Share it with him. हाँ, इसको मिटाते हैं. All right. So if you think about Supreme Court, if we try to figure out the structure of the Indian judicial system, we have discussed a lot about how Indian judiciary is independent. One more part will come tomorrow perhaps, or day after tomorrow, because Parliament is passing a law, so we have to go through it in a little bit more. So we will discuss that as well. Today we are going to understand this word called integrated, the first part that we have to cover. Now if you look at Supreme Court, the highest court of the land, and you read Article 124, it specifically mentions that Supreme Court will be the highest judicial body in India. Even though the terminology is different, but essentially Article 124 is mentioning about this, that Supreme Court is going to be the highest judicial body in India. So what it means, number one, when we say that it is highest or at the top, what is meaning of this? First, its decisions are binding on every other court, so all of them. Decisions are binding, right? Keep writing. Not only this, Supreme Court can transfer judges of other courts. So, decision about transfer. This is also here. Not only transferring of people or judges, but also transfer of cases. All right. So, we have further division in it. One is judges, other is cases. If you think about transfer of cases, what we come to know under Indian Constitution or constitutional framework, that there are two things available here. One, it can transfer the case to itself. So suppose there is some case pending in one of the court. The court, through its power, can take that case and can think upon it, can pass an order, and then that order, the copy of that order is reverted back to the court where the case was originally set up. And then that court, based on the order by the Supreme Court, delivers the judgment. This is one part. The other part is transferring from one high court to other high court. Alright, so transfer has two elements. Then it can issue writs. For your brief understanding, writs are like legal orders, special circumstances. And as far as Indian Constitution is concerned, They are usually issued when a person appeals or reaches court, or court comes to know that violation of fundamental right by an executive authority usually, or a judicial authority, has taken place. So fundamental rights here have important part to play. And then it can advise the president. So there is element of advice, and then of course other powers which we have just discussed through a concept map. This is what it means for Supreme Court to be at the top of hierarchy. Start writing. The Indian judicial system, the Indian judicial system is integrated in character, is integrated in character and structure. It is often mentioned as having a pyramid kind of structure, a pyramid kind of structure where Supreme Court is situated on top. Full stop. This makes Supreme Court the highest judicial body in India. The highest judicial body in India. Dash. Number 1. The decisions taken by Supreme Court, comma, laws declared as constitutional by the court are binding on all other courts. Second point, it can transfer the judges of one high court to other high courts. Third, it can move or transfer cases involving substantial question of law, to itself, or can transfer cases from one high court to another. Full stop. It exercises, next point, it exercises vast jurisdiction dash original jurisdiction original jurisdiction, jurisdiction in matter of appeal, jurisdiction in matter of appeal, comma, advisory jurisdiction, within bracket, non-binding advice given to the President of India, non-binding advice given to the President of India, comma, writ jurisdiction to enforce fundamental rights, comma, discretionary jurisdiction of special appeal, comma, power to do complete justice, power to do complete justice. So as you can see, if you look at the points that you have just written, these points themselves are substantial enough to make you understand how the court is the highest judicial authority in India. Now suppose there is a question in the main examination. What if UPSC is going to ask you a very simple question like, what makes Supreme Court of India the highest judicial body? You just have to write this paragraph. That's it, and your answer is done. If you're able to even paraphrase, go word by word, just bringing in some more articles, there is nothing better answer than this one. Alright, these 5 points. That's how you have to write. Now if we come to the next in the hierarchy, the high courts. Definitely the first important thing here is that their jurisdiction is, yes? Yeah, it is above the subordinate court, but it is below the Supreme Court. First is this, clear from the logic, I mean don't even need to mug up. Then there is something more which is added here. Not only the jurisdiction is above the subordinate court, there is something more here, that its area is limited in a state. Now, when we will be discussing High Court, at that time this question will pop up, but I have a homework for all of you. So, I am going to pass a statement and I want to know whether I am right or wrong. Every state in India has a High Court. Is this statement right or wrong? Every state in India has a High Court. Is this statement right or wrong? Nobody is answering. It is right. Okay. Now I am going to pass another statement. Let's see. Every state has a High Court situated in the okay. No, so Nakul got it right. Exactly. So go with the reasoning. There are many states, there are union territories, but not every state has a High Court in its territory. Okay, but every state comes under jurisdictional area of one or the other High Court. All right. So when you are going to look at the question, read the question carefully. So always keep in mind. Thank you, Nakul. Very good answer. Read the question carefully. Otherwise, हो गया खेला. वही answer गलत हो जाएगा. Right? Good. Very good. So we will come to it. So you have to figure out which state is under which High Court. It's a homework. If you don't figure it out, of course I will tell. But it's a homework. Now what this has to do? Simple. It exercises jurisdiction within the area. It can also issue writ within the area, within their jurisdiction, right? It works under the Supreme Court, isn't it? It works under Supreme Court. It cannot go against it. And then most important, of course, it's going to enforce fundamental rights. It keeps these court in check. So whatever these subordinate courts are doing, they work under the inspection or direction of the High Court. All right. So write next paragraph. After Supreme Court, the Indian judicial system, after Supreme Court, the Indian judicial system has system of high courts, has system of high courts. Even though not every state has a high court in its area, they all are through some provisions, brought under jurisdiction of a high court. Full stop. Working between Supreme Court and subordinate courts, the high courts exercise substantive powers. Number one, they can hear appeals made by petitioners. About judgments passed by the lower courts. Second, they can issue writs in their own jurisdictional areas. Third, they deal with cases falling. Okay, second is they can issue writs in their own jurisdictional areas. Second one, I'm repeating, is they can issue writs in their own jurisdictional areas. Third, they deal with cases both criminal and civil in their jurisdictional area. Last point, they exercise control and inspect the functioning of the lower courts. They exercise control and inspect the functioning of the lower courts. Now if we think about these one here, subordinate. So one is you enter the domain of district, right? So let's say you have a district here, and then there are certain metropolitan areas. Let's say big cities like Bombay, or Mumbai you call it now, Delhi, even Kolkata for that matter, and there are different districts, and in these districts there are further divisions. So you have a subordinate judges court, you have a provincial court, and you have a court of sessions, right? So let's say if we divide it further within district, what we find, we have a subordinate judges court, then we have provincial court, and we also have court of sessions. Alright, so suppose you are visiting some place, and usually in court of session, so session based court, they have criminal cases going on. So there is another name for these courts, they are criminal courts, only criminal matters. UPSC is not going to ask you too much detail, so only through basic understanding we will figure this out. Not only this, if you look at these court of sessions, we have further divisions. So you have a magistrate court, so there is a subordinate judge, then court of session, then a subordinate magistrate court, and then here only, as far as the third tier of government is concerned, we also have Panchayat Adalat. Okay, so you have further, you have a magistrate court and a Panchayat Adalat. Now with time, if you recall anything about Article 21 and how in Article 21 things have changed, even in the magistrate, we have an executive magistrate and a judicial magistrate. So whenever there is a deprivation of right to life and personal liberty, the court has mentioned that it should be done in front of a judicial magistrate, not an executive magistrate, to maintain separation of power. So here also we have further divisions. You have a judicial magistrate and a executive magistrate. Alright. And then if we further divide this, we have, let's say, वो सुना है नाम फिल्मों में, मुंसिफ साहब, who deals with wealth and all, and then there is न्याय पंचायत here as well, न्याय पंचायत. So if you think in terms of judicial system, what do we find? We have good amount of singularity till the high court level, but the moment you go at the level of subordinate court, things change. You have multiple kind of court system, and these courts are exercising judicial jurisdiction in their domain. This is a result of the judicial system that emerged through a history. Alright. In a sense that with British system, with British time, we developed these local courts, and when India became independent, we tried to brought all of this under one single hierarchy to ensure enforcement of fundamental rights. Same goes here. If you look at a metropolitan court, then also there are further divisions. Alright. So let's write this first, then I bring here, otherwise you people get confused. Right. Third part, subordinate courts. Subordinate courts. These courts are situated, at the lowest level at the lowest level of the integrated judicial system of the integrated judicial system of India. Full stop. In comparison to High Court, in comparison to High Court, there is diversity between states as far as subordinate courts are concerned. As far as subordinate courts are concerned. Write next point within subordinate court. Write next point. These courts essentially deal with criminal and civil cases in their limited jurisdictional area. In their limited jurisdictional area. And now what you have to do like this. Can I इसको मिटा दे? Can I wipe this part? ये लिख लिया ना सब लोगों ने ये वाला part? Okay. So I'm going to just get rid of this part. And in your copy, write as I'm speaking, they can be further divided. Into two parts. Right? So two parts in your copy is like this. Suppose this is your copy. So what I want all of you to do, just make two arrows. Go like this. Make one arrow here. Like this. बनाया सबने? Now write District and Sessions Judge Court. District and Sessions Judges Court. All right. Make a point like this. Write it down. Written. In this, have three arrows. So go like this. 1, 2, 3. Okay. In the first, write the Subordinate Judges Court here. Subordinate Judges Court. And in bracket write civil matter. All right. Then have this and make two further distinctions like this. 1, 2. And now write Munsif Court and Nyay Panchayat here. Right here. Munsif Court, which deals with majorly wealth issues, property, etc. And Nyay Panchayat, which is coming from the third tier of government. Alright, this is one. Then here write, make a line like this, write provincial small courts. Provincial small court. All right. And here write Court of Session. Court of Session in bracket criminal. In this, make a further division, 2 divisions precisely, right? Subordinate Magistrate Court and Panchayat Adalat. This line will follow, right? Subordinate Magistrate Court and Panchayat Adalat. All right. So basically, if you think in your copy, these are of the same level, right? They are of the same level. This, huh? And then have a further division in this. Make 2 arrows, right? Judicial magistrate and executive magistrate. Judicial magistrate and executive magistrate. Now come here, the second part. So this is 1. And then you have Metropolitan Court here. Metropolitan Court. And in comparison to District and Sessions Just Court, we have just 3 divisions here. 1, 2, 3. The first one is Metropolitan Magistrates Court. So we have a Metropolitan, same word, Magistrates Court, number 1. Number 2, City Civil and Sessions Court. City Civil and Sessions Court. And number 3, we have Presidency Small Cause Court. Just write Presidency here. Basically, it is working in the Kolkata region. So, Presidency Small Cause Court. As the name itself suggests, it's not going to deal with big matters. And this is a clear distinction here. So, you have subordinate courts, 2 parts, district, and it goes like this. Now what happens, UPSC is not going to ask you a question, too many questions from here. Basically they do not ask. For your understanding, you must have this map in your copy. Just in case something pops up or you have to talk with someone, you must have a map in your hand. That's we know how integrated is the Indian judicial system. So these are what is known as the meaning of integrated. That how it is integrated. So there is a lot of diversity at the state level, then you have high courts, and then at the top of the hierarchy is the Supreme Court. So if you have to go for a pyramid structure, this is how it looks. So you have Supreme Court, then you have High Court, then you have Subordinate Court, and in Subordinate Court you had these 2 parts. Alright, so there is a like roots. Roots of the integrated judicial system are right here. Okay, can we move forward? सबने कर लिया इसको, everyone has written it in your copy as well. Alright, chalo, good. So it also looks like roots, na? At the lowest level, too many roots are there, huh? Of a tree. Alright, let's move forward. In bits and part, I have already discussed about the original jurisdiction of Supreme Court to address one of the questions asked by UPSC. I think in the last class I have discussed it, or maybe last class, I don't remember correctly, but it has been done. Yet there were certain parts that were left. So now we move to the area of jurisdiction. Now there are 2 words. One is jurisdiction. The second is basically which is judicial in character or legal in character. Huh? There is a term called juridical, of a legal character. And then there is third term called jurisprudence. which basically means how law is being interpreted and made or constructed. You can also add the term philosophically by the judiciary. Here, this is what jurisprudence. Here, what you have is that something of a legal character or having legal authority, juridical in approach, legalist kind of thinking. And then in jurisdiction, this basically refers to area in which a particular court can exercise its power or authority. This is how you have to understand these three words, okay? For a basic fundamental understanding. Suppose there is something on the concept, don't need to go further deep down into these words, okay? Just write it down in your copy. There is something called jurisdiction, juridical and jurisprudence. This topic and this topic, these two both are important for your UPSC. This topic is connected with the term called demosprudence. This is important from UPSC perspective. Demosprudence is about PIL. Always remember this, demosprudence. If you mention this word in your answer, ho gaya kalyan, because the examiner will know the person is aware about the nuances of PIL. This topic is important as again from both pre and main perspective. Here you have basically the main examination perspective. Now if you think about Supreme Court, what do we have? We have number one, the original jurisdiction, right? Original jurisdiction. Now if you recall, it is about settlement of certain disputes. What is the prime object of this jurisdiction? It's about settlement of dispute. And UPSC asks a question, settlement of dispute between whom? Like, is it going to be state or government on the one hand, two or more states, central government and state on one part and other on the versus side, against whom? From here, two kind of questions have come in the past, and I think we have discussed both. They have both have come in the pre-examination and the main as well. In pre, you get a simple question and then something related to NCT of Delhi, which means what is the meaning of state under this article or under original jurisdiction. More than that, the second question which could be asked is what is the meaning of settlement? Are we talking about, let's say, some kind of financial obligation? Are we talking about areas of interest? And the one word answer is that every act of governance, either done by the central government or government of India or state government or any other entity in India which works in capacity as a state. Which is the third part? Works in capacity as state. Governance by all of them or between them is based on principle of rule of law. This is what settlement of dispute means as far as the constitution and your political apparatus is concerned. Start writing. Right? Jurisdiction of Supreme Court. Right? Number one, original jurisdiction. Original jurisdiction, Article 131. In this, right, the prime object, number 1 point, the prime object of this jurisdiction is to settle any dispute between Government of India and one or more states. Government of India and one or more states. Number 2, Government of India, any state, Government of India, any state or states on the one hand, and on the other, one or more other states, one or more other states. Number 3, between two or more states, two or more states. All right, and then write next point like a note, like a star. Make a star and give a subheading, meaning of state. Give a subheading, meaning of state, and write one statement. In the recent tussle between Government of India and Government of NCT of Delhi which the court established principle of harmonious cooperation, between these two levels of government, comma, substantiating the idea of cooperative federalism, comma, the court declared that meaning of the term state is not limited, meaning of the term state is not limited to, and then write, underline करके, you will understand, states only. full stop, write, the court declared that the intention of the framers was to develop a democratically accountable government at each level. To develop a democratically accountable government at each level. Full stop. Therefore, meaning of the term state must be derived through following a broad interpretation. So that question, who is going to decide the dispute between, let's say, Government of India and Government of NCT of Delhi? Will it fall under Article 131 or not? Initially, even the High Court was not able to address this concern, and that's why UPSC asked a main examination question here. This question has been asked, this idea, keeping this in the backdrop 2 times. So when we go through federalism and cooperative federalism, we discuss more upon this, alright? But keep this in like a star. Now there is one more thing in Article 131 which we have not discussed yet. What is that? There is a condition. There is a specific condition, satisfaction of which only the Supreme Court can consider some matter or dispute as pertaining to the purview of or falling under the ambit of Article 131. There is one condition here. Now what is that condition? The condition is very simple. This specific dispute here between these, okay, it must involve 2 things, and they have divided it. Sometimes these 2 words are merged, but for your understanding, keep it divided. It must involve question of law or fact. Alright, what is this? Question of law or fact, both. These 2 words must be kept separate. Sometimes what happens that the term fact is also read as a matter of law, that this fact is actually issue of law, or law could be stated as a fact. That depends on the approach you are taking. For your understanding, keep this in mind. If UPSC asks a pre-examination question from you, you must have these 2 words in your dictionary, question of law or fact, on which, on this existence or extent of a legal right depends. What is the condition further? Existence or extent of a legal right depends. So write this further. Next point, in this article, there is a condition. In this article, there is a condition. Any dispute must involve, any dispute must involve, and now underline, a question of law or a fact, a question of law or a fact on which existence or extent of a legal right depends. If you read Article 131 carefully, there is one more thing which is added. This article is not applicable in every matter. Alright? So there are some limitations put on the exercise of Supreme Court's power as far as original jurisdiction is concerned. So for example, if there is any treaty, any agreement, if there is, let's say, any charter or covenant which was in place before the commencement of the Constitution and it has sustained, and that agreement, charter, covenant, all right, etc., or any other, let's say any other treaty that contains a clause that on this particular agreement, on this particular treaty, this article shall not be applicable. So there is a limitation on it. So write this final 2 points, write a heading limitation. And write article exercise of Supreme Court's power, exercise of Supreme Court's power under Article 131, under Article 131 is not applicable, to a treaty, agreement, covenant, 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 charter. Sometimes they also use the term sanad for it. Okay, SANAD. Write this word, sanad. Or other similar instrument, made before or after the commencement of the Constitution, made before or after the commencement of the Constitution, underline the term commencement of the Constitution, that continues in operation, and, now underline, and contains the clause that this jurisdiction is not applicable to it, that this jurisdiction is not applicable to it. Full stop, or on it, is not applicable on it. Full stop. Write final argument in Article 131. Settlement of dispute means that the governance by any level of the government, governance by any level of the government is based on rule of law. Rule of law and principle of balanced power sharing, principle of balanced power sharing dash checks and balances between organs and level of the government, organs and level of the government as envisaged by the Constitution, as envisaged by the Constitution. Any doubt? All clear? What is original jurisdiction? So what do we get here? We get so many facts here, right? Number one fact. Which article? Article 131. Number two, is this power unlimited or there is some limitation? Limitation? Okay. Number three, which are the prime conditions? Settlement of dispute, yes or no? Right? Settlement of dispute, okay. Move further. Settlement of dispute between which or what? You have three answers and then one thing is added. So there is no union territory here. And one more thing is added, we will add it further, finance commission related issues, but primarily what is the meaning of state? We have to look at the capacity of the unit as well, okay. Then fourth, as far as this jurisdiction is concerned, what we come out with is that there is an element of governance based on rule of law. These are the 5 facts that you have to remember. So what happens if you limit yourself to a textbook, you only come to know about 2 or 3 facts. Not the 5 facts which must be kept in mind. मिटा दें इसको, ये ठीक था, समझ आया सबको? Article 131 clear? Okay. Alright, let's move forward. Now, when we move forward, we enter the domain of appellate jurisdiction. अभी break तो नहीं चाहिए ना? Break चाहिए? थक गए हैं सब लोग? Can we continue? You need break. It's almost 1 hour. Let's have 10 more minutes discussion, then we can have a break. Okay. Let's move on to the second jurisdiction. And here precisely if I have to ask me or if you have to take my sincere opinion, not many questions are asked from here. Original jurisdiction is something which is very important. These two jurisdictions are primarily they ask question from High Court sometimes. What kind of relation is between High Court and Supreme Court? So when we are finished with High Court, then we can have a better sense of the question. But we will move with it. Appellate jurisdiction. So what this is all about? If you read Article 132 and we move further, okay, we have a, let's say, we make a board here, let's have a line. So basically it is related to appeal. The first thing is, it is about appeal. Now of course, if there is an appeal, we need to have a petitioner, isn't it? Right? सिर्फ अपील थोड़ी होगा, कोई अपील करने वाला भी तो चाहिए ना, somebody who can appeal. And yeah, of course, there is going to be some subject. Very good. What's your name? Avinash. Good argument. So in addition to appeal, we need to have a subject. Appeal on what? And then we need to have a process, right? Through which procedure we are going to have appeal. ऐसे इसको समझेंगे ना आप. This is how you should start with it. Now, as far as this subject is concerned, we come to it in a while. The process is very clear. High Court has to certify. First process is that the High Court certifies that in eyes of High Court or in opinion of High Court, this particular matter has something, the subject, on which a proper appeal could be made. Now the first thing is that if you have to think about the subject, there must be a substantial question of law. Substantial question of law. So I want all of you to make this like अपना जो कॉपी है ना जो पोर्ट्रेट मोड में उसको लैंडस्केप मोड बना दो. Do it and start doing like this. Shift it. So write first Appellate Jurisdiction Article 132 and make points like this. Start writing. Right? लिखा है पक्का? लिख ले. Good. So if we move further, what we get here, so there has to be a substantial question of law about what? About interpretation of the Constitution. What is it? Interpretation of the Constitution. So in opinion of the High Court thinks that this particular question involves a substantial question of law about interpreting the Constitution. And when the High Court is certifying this, that yes, this particular thing involves this under Article 134A, that yes, there is a matter which requires interpretation by the court, and appeal shall lie to Supreme Court from any judgment or order or decree by the High Court. Okay. So there is this second element here added. From any, let's say, judgment, let's say decree, which is a legal order per se, and then the term used in the Constitution is final order. Final order. Based on any of these, if the High Court certifies under Article 134A that a substantial question of law about the interpretation of Constitution is concerned, an appeal shall lie to the Supreme Court. And then this petitioner can also add this as part of petition that there is a substantial question of law as per the interpretation of the Constitution. Now what this word is all about, final order, there is a specific meaning to it. You can understand it through like this. So don't think from the perspective of the judiciary. Think from the perspective of the appellant. The meaning is something like this. So final order refers to that order that if the final order is passed, including this question, if it is addressed, because the moment there is a certification, then definitely final order is still in the process. So that judgment could do justice for the appellant. Till then, there is no final order. Precisely meaning is this. So if there is an issue which is decided in favor of the appellant, the entire matter can be resolved. That particular order is known as the final order. So based on these three, a person can appeal. if the person gets a certificate from the court as well, and also in part of petition that person can herself say that this particular question involves a substantial question of law. So write this first, appellate jurisdiction, from the next page. Keep that portrait page separate because I will also discuss civil matter and criminal matter here. So we will have in one page, you will have a concept map. From the next page, write the heading appellate jurisdiction. Appellate jurisdiction. Right? First point, as per Article 132, first point, as per Article 132, when the High Court certifies under Article 134A, under Article 134A, that a particular judgment, comma, decree, that a particular judgment, comma, decree, or a final order, involves underline this, a substantial question of law, involves a substantial question of law as to the interpretation of the Constitution, as to the interpretation of the Constitution. Till Constitution you have to underline, comma, an appeal shall lie, an appeal shall lie to the Supreme Court, to the Supreme Court from any high court, from any high court in the territory of India. Okay, in the territory of India. Now there is one more question. Is there something more in this article? Article 132. Think from the perspective of petitioner. Now suppose the person for whom a particular judgment was passed by the Honorable High Court, that person thinks that this particular judgment has wrongly decided a question, okay, this question of law, it has wrongly decided. Then also this person can appeal. Okay, so write the next point. Suppose the person thinks, this petitioner thinks that this question has been wrongly decided. Okay, so in that concept map page, make this arrow, write wrongly decided, and then start writing. Under Article 132 clause 3, under Article 132 clause 3, any party may appeal to the Supreme Court that a question, a substantial question of law, has been wrongly decided, and then underline this, because there is a question which could be asked over here. When such certificate is given, has been wrongly decided when such certificate is given. So this certificate by the court is significant, okay, till article 132. When we reach article 134 tomorrow, because judicial activism will give more input on that, then another question will be addressed. So when such certificate is given, and then write the final argument, meaning of final order, meaning of final order, dash, write, the term final order refers to the deciding order, about a particular issue, the deciding order about a particular issue which, if it gets decided, which if it gets decided in favor of the appellant, then it is sufficient enough, to finally dispose the matter, So as far as article 132 is concerned, always remember two facts. First, there is a condition. What is the condition? That there is a substantial question of law which requires proper interpretation of the Constitution. Second, that this particular substantial question of law, in eyes of the petitioner, has been wrongly decided by the High Court. And including these two, bring the third argument, that there is a condition of receiving a certificate from the court, the respective High Court, that yes, there is a question that requires proper thinking or interpretation by the Honorable Supreme Court. These three are the prime facts that you have to keep in mind. Now let's move on to article 133. Get back to the concept map page. Okay, get back to that portrait landscape wala page. There we discuss. So what is article 133 all about? Now this is about civil matters. First thing. So as far as the Constitution is concerned and appellate jurisdiction of the court is concerned, there is a division between civil and criminal matters. And here also, what the Constitution says, if I bring this here, subject, a substantial question of law of general importance. A substantial question of law of general importance. First thing that you have to remember. Now the term general importance, don't consider is at generic. It means that it is significant. So it is not insignificant. Even the term general is here, it still means it is significant. Always keep this in mind. First thing. In addition to this, there is one more element to it. For example, that the respective high court is of the opinion that this particular matter must be addressed by the Supreme Court, that we need an address by the Supreme Court of India. This is the second thing which must be kept in mind here. Third, there is one more element in it, and there is one more. So the petitioner here, let's bring in the petitioner or the person who wants to appeal. The petitioner here is of the opinion. So we are not talking about the opinion of petitioner. This person is of the opinion that a substantial question of law has been wrongly decided. Here, this one, that a substantial question of law has been wrongly decided. This is the third thing here which we must be kept in mind. And then there is a, let's say, a kind of protection given to the judges, okay, and basically it's coming from idea of contempt of court. To ensure independence of judiciary, we need to make sure that there is no personal attack against one judge. Contempt of court, or let's say criticism of the judiciary, is not equal to personal attack on the judges. Let's think like this. Suppose एक माननीय न्यायाधीश महोदय हैं और महोदय हैं. There is a respected judge. He is delivering a judgment. It doesn't mean that this particular judge can be attacked personally. That is why there is one condition here which has gone through some legal revisions. That is not part of your concern. You should not go into that. Unless and until law is your optional paper, which I don't think any of you are thinking about taking law as the optional paper. Till then you don't need to worry about it. If Parliament has not by law provided otherwise, there can be, or no appeal shall lie to the Supreme Court against a judgment, decree or a final order given by one judge of a high court. Okay, this is the fourth condition. It's related to one judge of a high court. Alright, so these are, let's say, Article 133. So write it down fast because you have already covered the main points. We go through a summary. On the next page where you have already been writing, write Article 133, appeal in civil matters. Appeal in civil matters. Simple, write one paragraph. This jurisdiction can be exercised only when the case involves, number one, carefully, a substantial question of law of general importance, a substantial question of law of general importance, comma, right, address by the Supreme Court in opinion of High Court, address by the Supreme Court in opinion of the High Court, or wrong decision taken on a substantial question of law, on a substantial question of law, in opinion of the petitioner, in opinion of the petitioner. Now we move on to the next article, and after that we can think about the break, so don't worry. हाँ अभी tired तो नहीं, एक और कर ले, एक और अनुच्छेद, one more article. So here we move further. So now in addition to the civil matters, there will be certain issues that deal with, let's say, death sentences, or punishment. So the prime thing is about, let's say, punishment, death sentence, etc. And always remember, as far as this article is concerned, the history of courts shows, it's like a general understanding I want to develop all of you, your general understanding, that the history of Supreme Court shows that Supreme Court is not working on sympathy. It works on substantial legal grounds. So not many decisions have been reversed. Alright? And I don't want any of you go through this part because it is dangerous. तुम लोग का हालत खराब हो जाएगा. So what happens here? Now suppose there was a person in the lower court, that person was free in the judgment, but उसका दुर्भाग्य था. दुर्गति वर्ड समझते हो? दुर्गति होना. Suppose durgati happened with that person, and in the high court the good judgment was reversed. So what happens first? Let's say there is a reversal of judgment. Suppose this happens. And not only reversal. So now in reversal, that accused person has been sentenced to death. कि दुर्गति में भी बड़ा वाला हो गया कि चलो उम्र कैद नहीं, बोला गया इसको टांग दीजिए. So while reversing, the honorable court sentenced the person to death कि आपकी जरूरत नहीं है. Suppose this happens. आप चाहते हैं आपके साथ ये सब हो? हैं? कोई चाहता है कि ये सब हो आपके साथ? नहीं ना. So suppose this happens. Then there is something more. Not only this, what if the High Court thought that this matter is not going to be addressed by the lower courts? So first they withdraw the matter. पहले क्या किया? Withdraw किया, अपने पास बुला लिया. Alright. And then after withdrawing the matter and deciding upon it, again they sentenced the person to death. फिर से उसको टांगने की बात हो गई. Alright? कि इसको जो है आप टांग दीजिए. And the trial before itself they said कि भैया इसको खत्म करो. Or the High Court certifies that this particular question must be addressed by the court. The High Court certifies that it must be addressed by Honorable Supreme Court. So if these three things are happening, then definitely we have a appeal case in matter of death and punishment. So just write it down, Article 134, write Article 134 and write like this. An appeal shall lie to the Supreme Court. An appeal shall lie to the Supreme Court if number one, the High Court has reversed the acquittal order reversed the acquittal order of the accused, has reversed the acquittal order of the accused, and sentenced that person to death. टांग दो इसको सूली पे से, मार दिया जाए. हाँ. Second, the High Court has withdrawn trial from subordinate authority, has withdrawn trial from subordinate authority, and in the trial before itself, has sentenced the person to death. And third, the High Court certifies that the case is fit for an appeal to the Supreme Court. All right, for an appeal to the Supreme Court. Now, as far as Article 134A is concerned, don't go into too much detail. Just keep two facts from this article. Only two facts. Very simple one. One is that the specific individual, okay, so the person herself or himself. So let's say the person may herself or himself, or if an oral application is made by the aggrieved party, the conditions of giving certificate, if an oral application is made by the aggrieved party. So here you can see that the court has expanded the zone of providing justice. They are referring to oral application as well through the constitution. So oral application is proceed, or if an oral application is made by someone on behalf of aggrieved party. In all these cases or all these circumstances, a certificate can be issued. So if you think in terms of, from the UPSC perspective, they have not asked question from here because it is too into detail. So just for your concept map chart, right, Article 134A, may herself or himself. 2, if an oral application is made by the aggrieved party, and third, arrow down, by someone on her or his behalf, So this is the appellate jurisdiction. That's it. Nothing else is needed. Okay? You all need a break? थकान हो गया? Alright, so 6:43, 6:44 in my clock. 5 minutes break, all of you. 6:49 we meet. Okay, and then we start with 6:50. Yeah, so this topic is basically a topic of social rights. Okay, Nakul, your question is very good. For today's class, I have to give you one answer. So don't look at, so there is this term called if here. So if it certifies, okay. In the constitution, if you look at the core text, there is nothing about what if it doesn't certify. Okay, But what happens here, there are in, let's say, Taneja case and some other cases as well, based on both criminal procedure and the civil procedure, the Supreme Court acts in an integrated manner. Remember why this if is not a matter of concern here, because the next articles we are going to read further enlarge the jurisdiction of Supreme Court. The court has said very clearly that judges cannot simply dismiss the appeal. They have to give very solid reasons for dismissing and not giving a certificate, first. Second, if the court itself thinks that this particular matter needs to be heard, there is a provision for a special appeal, in which the petitioner doesn't get the right, but the court interferes. So here the Supreme Court and the Constitution is relying on the integrated system of judicial apparatus or Indian judicial criminal justice system. So don't think like this, the court is not giving. There is going to be a substantial reasons for not giving. And then in one of the matters, the court had further said that there is a provision for coming through a new case right into the Supreme Court, and you can attach these cases as well. That will be discussed in the social rights issue. For today's class, only refer to two arguments. There has to be solid ground, and then the court can interfere itself as well and take the matter beforehand. The most famous case is the Taneja case here, which actually established this principle. But that is like going into law. So don't go into law. GS, get back to GS foundation. My prime concern is GS foundations. I keep that in mind. Okay, come back. It's 6:50 on the clock. Come back. All right. Let me. इसको मिटा दें, ये सुंदर सा जो बना हुआ है बहुत प्यारा सा, इसको मिटा देते हैं. अब आगे बढ़ें. हाँ, मिटा दें इसको. ये सबने कर लिया, छाप लिया आप लोगों ने. चलिए. Because now we are going to enter something more interesting and which is very essential from the main examination perspective. The topics we are going to enter now. Let's get to it. So what happens if you follow every article, every substantive article, the polity becomes easy. That you are following a chain, a sequence. Huh? Let's go to it. All right, let me bring it here. कुछ होगा नहीं, बाइसेप जरूर बन जाएगा मेरा थोड़ा बहुत, इतना इसको मिटाना पड़ता है ना. चलिए, लेट्स एंटर. हाँ, so I want to begin with, so article 134A, keep 135 aside for few days. I want to begin with article 136 because we are dealing with appeals. This is a very important article. Let's say article 136, 131, 132, 133, 134, 141 and 142. These are of a different variety altogether. But this article has a different connotation to it because this has been used by the court in, let's say, a democratically transformative manner. So this is something like this, that special appeal article, special appeal, and it deals with special leave of the Supreme Court for the appeal. So we are going to have, let's say, special leave of the Supreme Court of India for the appeal. Now the first thing that you have to keep in mind while understanding this article, as far as your UPSC is concerned, it is not similar to other articles of appeal. Okay, so whether it is article 133, 132, it's not like that. There is a difference. So unlike the right to appeal. First thing you must keep in mind. Now, what this article is all about? If you read the text of the Constitution, there are certain words which tell the character of this article. For example, the Constitution says that notwithstanding anything written in this part or the chapter. So we are going to have a division here. So what it says, notwithstanding anything written in this part or chapter. So we are talking about other jurisdiction. We are talking about appellate jurisdiction here, right? Appellate jurisdiction, also original jurisdiction, and others. So we are talking about writs. We are talking about advice. Everything is included here. And this article states, it begins like this: notwithstanding anything written in this part of the chapter or any other provisions, the Supreme Court can use its discretionary power. The term Constitution is using is discretionary power. Very significant. And using this discretionary power, it can grant a special leave to appeal. It can grant a special leave to appeal. Sorry. From any judgment or order or decree or determination or sentence or any other matter on any cause passed by or made by any court or tribunal in the territory of India. So what do we get here? Whether it is a judgment, whether it is a decree, whether it is a order, whether it is a sentence, whether it is a determination, the court has decided something, it can grant a special appeal to leave, a special leave to appeal in these matters, and whether or not it is granted by, let's say, any court or any tribunal. So what do we get here? Not only we get the entire judicial system under its ambit, isn't it? If you focus on these words, any court, so it's including all high courts and all the subordinate courts. If you come with the idea of writs, so we're getting all those tribunals that exercise certain kind of judicial power. It doesn't matter whether an executive officer is sitting there in a judicial capacity. Even that will also come under this. So in all of these matters, if Supreme Court can, using the discretionary power, grant a special leave to appeal. But it is not like this. This is different. Right to appeal is different. Here, the right to appeal goes to the petitioner or the party. Here, it stays with the court. First thing. And the court interferes. Now, what has happened? Through a series of judgments, the court has expanded the meaning of this right. The court has interpreted the Constitution in such a manner that this entire article has become a source of immense power for the Honorable Supreme Court. For example, the first thing that you have to keep in mind, which came out into a very important case, this article 136 is about corrective jurisdiction. So we first discuss this, then we move forward to what it actually other parts are included in. So there are two kind of justices. If you recall my class on preamble, any of you, while discussing preamble and the idea of justice in it and linking it with equality, I mentioned that justice can be of two kinds. One could be corrective justice, also sometimes known as rectificatory justice, and one could be distributive justice. Okay, so if you bring idea of justice here, there is, let's say, corrective justice and there is distributive justice. Distributive justice in very simple terms is about allocating resources or distributing resources. So for example, if you read article 39 or even article 15, it falls under distributive justice. Basically we go for DPSP here. It's about distribution, as the name itself suggests. But what is this thing here? Corrective. It means that something was done wrong. है ना? Correct करना है ना? You have to correct it. Something wrong was done and it is falling under article 136. It means something wrong done by the judiciary. Whether it is a court or whether it is a tribunal. So something wrong done. And now the court, using article 136, is trying to rectifying the wrong. Rectification, ठीक करना उसको, जो गड़बड़ कर दिया है उसको अब ठीक करना है. They are trying to rectify it. And why rectifying, or through rectification process, the court is trying to ensure justice. Alright, बहुत ही simple रहना है. Through rectification, the court is trying to bring or do justice. So corrective jurisdiction, jurisdiction apply किया, गलत apply किया, it was wrong. Now they are going to rectify it. First meaning is this. And through rectification, something happens. So let me add a line here. ऐसे करते हैं. Let's have it here. We bring this argument here. यहाँ पे. So what happens? When the court is applying this article, when they are rectifying, the court is going to definitely overturn the previous judgment. Okay, it is going to change, na? Or add something. Previous judgment. Or order, whatever you call it, decree, sentence, determination. So what happens through this, what the court is doing essentially, that it is settling the law clear. Okay, first is this corrective jurisdiction, and through corrective jurisdiction, it is going to settle the law clear. What is meaning of this? What law means, how it has to be implemented, what are the provisions of this law, what is rule of law as per this law, everything will be cleared. So it is going to be number one as a binding precedent. Binding precedent, which means that not only for this case plus future cases will be decided based on this kind of clarification of law. So article 136 is about corrective justice. The first thing that you have to keep in mind. Clear about corrective jurisdiction? What is the meaning of this word? Start writing. I want all of you to write, because 136 and 142, anything will come from this article in the UPSC main. I am taking a guess, article 142 is the prime one because recently a case has occurred. So they could ask a question from article 142. Write article 136 and write like this: special leave of the Supreme Court, special leave of the Supreme Court for appeal. Or go something like this, go very simple, special leave to Supreme Court for appeal. Special leave to special leave, write this, special leave, special leave by special leave to appeal by Supreme Court, write like this, special leave to appeal by Supreme Court, right? First point, special leave to appeal by the Supreme Court, article 136, right? First point, as per the Constitution, the Supreme Court of India, as per the Constitution, the Supreme Court of India, by using underline the discretionary power, underline the discretionary power given in this article, the discretionary power given in this article can grant a special leave, can grant a special leave to appeal, special leave to appeal from any judgment, comma, decree, comma, order, comma, sentence, comma, determination in, now underline, any cause or matter, write both these words, underline, any cause or matter passed, any cause or matter, underline both the words, passed or made by any court or tribunal, by any court or tribunal in the territory of India, in the territory of India. Now give a subheading, important facts. Important facts. Right, number 1, it is a special jurisdiction. It is a special jurisdiction. All right. Then write second point, it is discretionary in nature. It is discretionary in nature. And then write third point, in state of Punjab, versus Rasik Masih, Rasik Masih case, the court used following words to refer to this article. Now have a double inverted comma and write this statement. It can be described as a residuary power, extraordinary in its amplitude, its limits when it chases injustice, is the sky itself. So as you can see, the court has explained residuary power, which means all those powers that were not written in the constitution, not applicable, not mentioned anywhere, but all of these rest with the court. So there is no limit to it. Second word, extraordinary, right? And third, when it is chasing injustice, what is the limit? The sky. So it actually means unlimited, right? Then mention this word as well, discretionary. Okay. Now write next point. It is about corrective justice. It is about corrective justice. Dash the court while exercising this power, tries to rectify the legal wrongs, and through this process settles the law clear. Through this process settles the law clear. Right, next point. It acts and make an arrow like this. So between 2 points make this arrow. Settles the law clear. Beneath this make this arrow and write it acts as a binding precedent. It acts as a binding precedent for the future cases. Alright. Then if you read this article further, we get something more to it. Let's say third is here. What it is? It does not confer any right to appeal. It does not confer any right to appeal. So it is not like Article 132, 133, 134. No, it's not like that. It does not confer any right to appeal. Rather, more than this, to any party, let's say. So it is not regular in its orientation. So it's not regular. Rather, it confers rights or power or authority to the Supreme Court. Instead of the petitioner, who is getting the authority here? The Supreme Court. So it is giving authority to Supreme Court. Supreme Court of India. And authority for what? That's the next question which must be asked. Authority to interfere and establish justice. Establish justice. Right, next point. This article does not confer any right to appeal to any party. Full stop. It is not a regular form of appeal. It is not a regular form of appeal. Okay. Next point. It confers extraordinary powers. It confers extraordinary powers to the Supreme Court to interfere in suitable cases for establishing or bringing justice. Then something more in this article, which will be a bit difficult to understand at this level, but I hope I will try to make you all understand in a simplified manner. So there is something known as non obstante clause in legal jurisprudence. Non obstante clause. So what it means, just try to figure it out. If you think about Article 136, because recent days when we talk about judiciary and governance, Article 136, Article 131 and Article 142, they become most important. Alright, and Article 13, 32, definitely we will cover that, as we have already covered 13 and 32, but by the end of the course you will get the entire picture altogether. So what happens, there are certain clauses which have an overriding effect. What kind of effect? Let's say overriding, to override. So what Supreme Court has done is that this particular article, Article 136, with the language that is discretionary, any court, any tribunal, any judgment, order, sentence, determination, whatever the namesake, what the court is decided that this is a non obstante clause, which means it is not subsidiary or secondary to any statute. any law made by, let's say, a state legislature or something else. It is not subsidiary to a provision. What is saying? Notwithstanding anything in this part of the chapter. So the court has said that this article has a overriding effect on other statutes. It has an overriding effect on other laws, on other provisions. So it is going to be on top of that. The other clauses have to be subsidiary to it. Alright, so a non-obstante clause. Write this point. Non-obstante clause, this argument. This is E here, non-obstante clause. Right. This article has an overriding effect. An overriding effect. Full stop. It gives the court special residuary powers. It gives the court special residuary powers which are unfettered, by any statute, or other provisions of chapter 4 of part 5 of the Constitution, or any other provisions of chapter 4 of part 5 of the Constitution, which means that in eyes of Supreme Court, this article is outside the purview of ordinary law. Outside the purview of ordinary law. So write next point. Article 136. Article 136 is superior to and outside the purview of ordinary law. Full stop. It goes beyond ordinary legislation. It goes beyond ordinary legislation to meet the demands of justice. To meet the demands of justice. Then one more element which is important from the main examination perspective. It is about eradicating injustice. Write this point as well. Next point. It is about eradicating injustice, especially on matters that involve question of law of general public importance. Question of law of general public importance. and is used especially on a decision that has shaken, or let's say that shook the conscience of the court, and then write one final argument. Though THOUGH, though it does not confer the right of appeal, the court can take multiple recourse. This is Article 136. If they ask you a question from the main examination perspective, just write these points. If they ask you 150 words, summarize. If they ask you 250 words, in your material and aid, I will give you 2-3 more cases names. Add those names, done, period. The answer is done. This is another topic from the UPSC main examination perspective. Are you all tired? थक गए हो सब लोग? आर्टिकल 136 का आइडिया समझ में आया कितना इंटेंस आर्टिकल है? इट्स नॉट अ सिंपल आर्टिकल. थके तो नहीं हो ना? इज इट इंटरेस्टिंग जुडिशरी? है थोड़ा सा. अच्छा, अरे टाइम पूरा होने वाला है. एक काम करते हैं, लेट्स हैव अ मैप बेस्ड डिस्कशन फॉर व्हाट इज अबाउट टू कम, एंड देन आई विल लीव ऑल ऑफ यू. ठीक है, फिर छुट्टी कर देंगे. 5-7 मिनट रुकेंगे साथ में आप लोग, थोड़ा सा और इसको मिटा दें. ये सबने पिक्चर लगा ली. देखिए, यही है आपका सिनेमा. इसी में शाहरुख खोजो, सलमान खोजो, जिसको खोजना इसी में खोजो. अगला 1 से 1.5 साल तक यही खोजना है. ऑलराइट, हम इसको मिटा रहे हैं. अब बहुत इंपॉर्टेंट बात करते हैं, सो दैट what is about to come, another exciting topic in judiciary. So I am very happy when I teach judiciary. मेरा biasness है judiciary पढ़ाते हुए, आप ऐसे भी समझ सकते हैं कि मुझे बहुत अच्छा लगता है पढ़ाना. But from the main examination perspective, 2-3 topics are part of this. So there is Article 142, there is Article 141 as well. There is the idea of judicial review, and there is the idea of judicial activism, the concept map that I just shared at the initial moments of the class. So what do I have to teach here? So let's say there is Article 137, and let's have इसको भी मिटा देते हैं. So I'm going to give you a map of 2 classes or 1.5 classes that we are going to have. There is Article 13, and there is Article 142 as well. Add 136 here, and there is a difference that will come to it. So if you think about Indian Constitution, Article 137 is about review of order and judgment by Supreme Court of India. Read it very carefully. The only time when we have this term called review, it comes here. So when they ask judicial review, only thing we have here is review of order and judgment by the Supreme Court. So here Supreme Court is again going to review its own orders and judgments. So we are looking for what kind of justice? Corrective justice. Very good, Avinash. Avinash, right? Very good. Corrective justice here. Simple. You think Article 13, as far as this article is concerned, what we are getting here is any law made by the Parliament which is wholly or in part inconsistent with fundamental rights will be declared null and void to the extent of violation. Okay. So if Parliament makes a law which is inconsistent or infringes or violates fundamental right, then to the extent of violation, the law will be declared null and void. Alright. So extent of violation is important here. Suppose there is a law, let's say A to B is a law, and let's say till A to P it's fine with the fundamental rights, but from P to B it violates fundamental rights. So only this part will be declared null and void by the Supreme Court. We have another name for it, we call it Doctrine of Severability. Which doctrine? Doctrine of Severability. This is a legal doctrine. Again UPSC pre-question. UPSC pre-question, where the reviewer comes in. If I bring in Article 32 here, then against executive and also people acting in judicial capacity, both, against their actions, if these actions are violating fundamental rights, Supreme Court can issue writs, right? समझ आ रहा है? Following. If I bring Article 142, this was again special leave petition, which you have seen many features, extraordinary, etc., etc., all of those features. This is power to do complete justice. In words of Supreme Court, the Constituent Assembly has given Supreme Court constituent power here. It can do anything as guardian of the Constitution. Just 2 or 3 more minutes. If I bring in Article 21 here, nobody will be deprived of their right to life and personal liberty except by the procedure established through law or established by law, right? So we are talking about a procedure here. Honorable Justice Bhagwati, after Menka Gandhi case, has expanded the meaning of procedure. And many argue that instead of procedure established by law, they have brought in due process of law. They have expanded the meaning of procedure to such an extent. All these 4 combined with the recent invention of PIL or public interest litigation by the Honorable Supreme Court, where before PIL, what was the matter? The person who is aggrieved, जो पीड़ित है, only he could approach the Supreme Court. Post public interest litigation, you, me, anyone on behalf of an aggrieved person can file a public interest litigation through letters. Earlier they used to take letters as well, now letters are not part of that, but they can have a litigation. So if you bring all of this and get PIL, what we get is the phase of judicial activism. So the next class is and the next topics, because UPSC is asking question from this perspective. How judiciary has expanded democracy in India. When I was going through questions, I was surprised to see that UPSC is not asking you only core polity questions, traditional fact. UPSC is asking whether you understand the role of judiciary in the system or not, how it has developed. So UPSC is going to demand answer from you based on these kind of background, that you are aware about it. So in the next class, we begin with this big shot. Okay, and we go through certain cases. Thank you. Thank you. And we go through 2 main examination questions. उस पे देखना कैसे लिखना होता है. Okay, see you.